Good evening. We, the unwilling, led by the unknowing, are doing the impossible for the ungrateful. We have done so much for so long with so little. We are now qualified to do anything with nothing.
I'm ordering you as a condition of your bond not to participate in this kind of behavior again.
Arraignment only, please. Who's your person?
Mr. Flores, Thomas Flores.
You need a translator? Translator?
No.
Okay, are you ready? Let's roll. Let's roll, nerds. All right, you're Thomas Flores? Mr. Flores, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
On March 11th, 2025, officers observed a vehicle speed past their vehicle, shaking the patrol vehicle due to the high rate of speed and run a red light. The officer observed vehicles traveling on the green light slam their brakes to avoid hitting the defendant. The officer also observed the defendant weave in and out of lanes 3 times without signaling. A traffic stop was initiated. The officer advised the defendant he was being detained for reckless driving. The assistant district attorney accepted the charges, and the defendant was advised that he was being placed under arrest and needed to exit the vehicle. The defendant refused to exit the vehicle and stated the officers would have to break the glass to remove him. Officers made entry into the defendant's vehicle and placed the defendant in custody.
By chance, you know how fast? Does he say? Because he says a high rate of speed so fast that the car shakes.
Yes, and that's all they have in the dim summary, Your Honor. And then it's him running the red light, causing people with the green light having to slam on their brakes.
Okay. Mr. Flores, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license, please?
Yes. His driver's license is eligible, Your Honor.
I'm ordering you as a condition of your bond not to drive in this manner again. If I see you drive like a complete maniacal person, I'm going to take your privilege drive away, and then I'm going to put you in jail. Do you understand? I will protect my street at all costs. If that means putting you in there with an extremely high bond, I'll do it in a heartbeat. No reckless driving, street takeovers, donuts, anything of this nature. Do you understand? You are also not allowed to drive unless you have valid liability insurance in your name as well. All of these are your bond conditions. If you will have you sign these bond conditions now, you pick up a new case. If I find out anything, do you understand? Now, because you have a lawyer, I will waive your appearance. So you don't have to waste your time coming to court, but you must stay in touch with counsel. If he tells me he can't get a hold of you, you pick up a new case, you act like a bonehead. It's not going to go well for you. Do you understand?
Senor.
All right, I'll have you sign a reset with Victoria. We'll have you meet take a seat in the jury box when we get your bond conditions. We'll have you sign it, and then you'll be free to go.
Thank you, Your Honor.
Thank you, Your Honor.
So do you mind filing those conditions?
Did you want the case number?
Yeah.
5555528. Lundy, come on up.
Morning, Your Honor.
That way.
Well, good morning. Top of the, it's Friday Eve.
Yes, happy Friday.
Wednesday.
Did you get it, the cost number?
Yes, I did.
Yeah. Okay. Good morning, Mr. Lundy. Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 12th, 2025, at approximately 4:45 p.m., an officer was dispatched to an FSGI call. Upon arrival, the officer spoke to the complainant, who stated he was traveling north on FM when a vehicle crashed into his vehicle. The driver then fled the scene without exchanging information. Complaining witness to the passenger stated that they were rear-ended, causing the defendant's vehicle to crash into a ditch. Defendant then approached them to check on their welfare, and once he saw they were unharmed, the defendant fled the scene on foot. The officer observed significant rear-end damage to the complainant's vehicle. The complainant provided a description of the defendant, and the officer ran the license plate and found the registered owners were Michael Lundy and Dylan Lundy. On March 13th, 2025, the officer received a call from Lundy, who wished to provide a voluntary statement regarding the incident. The defendant admitted to crashing into the complainant's vehicle and to fleeing on foot because he believed he had an open warrant for failure to appear for a window tint violation. The complainant positively identified the defendant by photograph. The estimated cost to repair was over $200 as the complainant believed their vehicle was totaled.
Can you run his license, please? And does he
Yes.
have any open cases anywhere? You can run an NCIC.
His driver's license is eligible. And I normally don't take note of Class C violations, but I do.
No, I don't care about Class C.
Right.
Didn't-
Um,
No, I don't care.
he does not have any open
Nope.
cases
Okay.
at the moment.
Got it. All right, Mr. Lundy, I'm going to find there's sufficient probable cause to go forward with the case. The only condition I'm placing on you now is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you may not drive. You understand?
Yes, sir.
Okay, I will waive your appearance because you have a lawyer. Just stay in contact with Will. He'll tell you if and when you have to come back to court. I'll have you sign a receipt, Victoria, while you take a seat while we get your conditions. You'll sign it and then you'll be free to go.
Thank you, Judge.
Don't
Thank
pick up
you,
any new cases.
Yes, sir.
Is that pre-trial bond condition?
Estates conditions.
Okay.
Okay,
Next is
so-
on page 12. Howard, come on up.
Can you file those, please?
Good morning, Your Honor.
Hi, how are you, man?
I'm doing good, Judge. How are you?
Good. What was the last name?
Howard,
Okay,
page 12.
there we go. Right. Good morning, Ms. Howard. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
On March 16th, 2025, an officer observed a vehicle driving the wrong way on Durham Drive in Harris County, Texas. The officer asked the defendant to step out of the vehicle. The officer observed the defendant to have bloodshot eyes and the moderate odor of alcohol emitting from her. The defendant stated she was coming from Clutch Bar and had one shot. The defendant stated her GPS told her to go the wrong way. SFSTs were conducted. 4 out of 6 clues were observed on the HGN. 3 out of 8 clues observed on the walk and turn, and 1 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to providing a breath sample. The results were 0.119 and 0.123.
Okay, Ms. Howard, I'm going to find that there's sufficient probable cause to go forward with your case. Do you mind running to see if she has any priority to be licensed, please?
Yes, Judge.
And a license?
She does not, and her driver's license is eligible.
Okay. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You understand, ma'am? You have a lawyer, he'll help you out. Just stay out of trouble. Don't pick up any new cases. If your license does get suspended, you may not drive and Con will keep you in the loop. For now, I'll have you sign a receipt with Victoria. We'll have you get your conditions with Felicia and then you're free to go. Thanks, guys.
Thank you, Your Honor.
Have fun. Good to see you.
Good to see you too, Judge.
Page 16. Phillips, come on up.
Morning, Judge.
Hi. You say 16? Okay.
Phillips.
Good morning, Mr. Phillips.
Good morning, Your Honor.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 12th, 2025, at approximately 9:25 a.m., an officer was conducting a stationary traffic enforcement on a public roadway of the 7,000th block of IH 610 southbound in Harris County, Texas. The officer observed a red Ford pickup truck traveling at a high rate of speed with heavy traffic the posted limit was 60 miles per hour. The officer witnessed the pickup truck bypassing other motor vehicles, weaving in and out of traffic at high speeds and coming dangerously close to other motor vehicles, with other drivers having to brake to avoid collisions as the Ford cut in front of them recklessly. The officer witnessed the pickup make multiple unsafe lane changes. A traffic stop was initiated. The officer reached speeds up to 110 miles per hour to catch up with the truck, but the pickup continued to distance itself from the patrol vehicle. The officer made contact with the defendant, driver, and sole occupant. The defendant admitted, "I know I was driving like an idiot. I just got off work." The defendant acknowledged he was aware that he could have caused an accident and hurt someone.
Mr. Phillips, I'm going to find that there's sufficient probable cause to go forward with the case. If I find that you drive like this again, it's really not going to go well for you. Do you understand?
Yes, sir.
I will protect my street at all costs. If that means putting you in jail with a $500,000 bond, I'm going to do it in a second. Do you understand?
Yes, sir.
Anymore, I will also take your privilege to drive away from you as well. Can you look to see if he has a license?
Yes, his driver's license is eligible, Your Honor.
You are not allowed to drive unless you have valid liability insurance in your name, and that is also now a condition of your bond. No reckless driving, maniacally driving, donuts, street takeovers, anything of this nature. Do you understand?
Yes, Your Honor.
You will sign conditions to this, and after that, you'll be free to go. You have a lawyer, I will waive your appearance. Just keep my street safe, man. Every day we have people dying. It's not fair. Do you understand?
Yes, Your Honor.
Okay, come on.
Thank you, Judge.
Right this way. All right, Judge, next is page 1, Al-Bardon. Come on up. All right, house May 2027.
I can work with it. Stand right here. in the middle. I'm the judge. Yes, sir. Thank you.
You can call Flores up now if you want to sign conditions as well. Sign those. What page did you say?
Page 1, top of page 1.
You were Mr. Al-Bardon? Sir, you're charged with terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thomas
On
Flores?
March 12th, 2025, an officer responded to a weapons disturbance call at a residence in Katy, Harris County, Texas. Upon arrival, the officer met with the witness who stated the defendant, her brother, and the complainant, her sister, were inside the residence and were involved in a verbal disturbance. The witness believed the defendant walked upstairs to retrieve a firearm during the altercation, which caused her to walk out of the residence and call 911. The witness, the complainant and the defendant were eating at the dinner table, and the defendant told the complainant that he will shoot the complainant and the complainant will need to leave the residence. The complainant stated that she lives at the residence with the defendant. The complainant stated the defendant got into a verbal altercation with their father, and the defendant stated that he was the man of the house. The defendant attempted to slap the complainant in her face, and the complainant moved her head back, causing her hijab to fall off her head. The defendant told the complainant he would grab a gun, hold her down, and shoot her. The defendant would see that the complainant would not be in the residence. The complainant stated she felt in fear when the defendant threatened to shoot her.
Mr. Al-Bardon, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case that identifies Ms. Lubna as a protected individual. Get to know this protective order, because if you do something to violate it, the state can and will file a violation of a protective order against you. And it's one of the worst cases that you can pick up. Do you understand? One of the things is this comes with a residential restriction that you're not allowed within 200 feet of the Park Fair Courthouse. Do you understand? If you go back to this place, it's not going to go well for you. Do you understand? How old are you, sir? How much? 33. Do you work? Do you have the ability to hire a lawyer? So what I'll do is I'll have you fill out an application for me. I need to know whether you can qualify for a court-appointed lawyer. Any allegation of alcohol or McKinsey? Any alcohol or any dope or anything like
No
that?
allegations of alcohol.
Okay. So for now, what I'm going to do is I'm also ordering you not to have any contact with this person and not to be in possession of weapons. Do you understand? I'll provide you a lawyer today and we can talk about how we go forward, but just be careful. I don't want to have to put you in jail. Do you understand? Okay. Do you mind giving me an application? Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box. Do you have the rip done?
Yes, I did speak to the complainant.
So what do they want?
They did not ask for no contact. My position that there should at least be some sort of cooling off period after something like this, even though.
Are they okay with having contact? Or no?
Yes, they would be okay with having contact.
Where's he gonna go? Do they know?
Yeah, that's true.
Because he's not working. Where is he gonna go?
Right. And I spoke to both the witness and the complainant, and both of them would be okay with him going back to the room.
Okay, so let's get him a lawyer and then we'll figure it out. Okay. Definitely no weapons, you know?
Definitely no weapons. We'll talk about it when.
Yeah, okay. Frederick, do you have an arraignment?
Good morning, Judge. I don't think I have an arraignment, but I do have.
Do you mind? Please, thanks. Hold on, I can't hear you.
Let me.
Give me a second.
Judge.
No? Okay. Are you ready?
For the next one?
Yeah.
Page 6, Bur.
Let me just blow through the arraignments, Frederick, and then I'll hit you up, okay? Please. I don't think there are many. Say something.
Hello, Judge. Can you hear me?
Go. Okay.
All right, got you.
Thanks. I just need to make sure it's the speaker's on. Hi, Sylvia. Do you have an arraignment? No?
No,
Okay,
sir.
let me finish with this and then I'll hit you guys up.
Sure, absolutely. Good morning.
Bottom of page 6, Judge.
Good morning, Miss Burse.
Sorry, I lost my voice.
Burse, that's what's right, right?
Yes.
Okay, ma'am, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. Just hang tight and we'll, okay?
On March 13th, 2025, an officer responded to a criminal mischief call at a residence in Harris County, Texas. The officer made contact with the complainant and the witness who directed the officer to the scene. The complainant stated the defendant came to the location, broke his motor vehicle window, and recorded the incident on his phone for the officers to see. The complainant stated the defendant left the location in a black Kia that had the location on. The complainant stated the defendant was on Rust Creek Drive at an apartment. He could point to her apartment. The cost of the damage to the motor vehicle was approximately $500. The officer reviewed the video and observed the defendant striking the front passenger window, causing the window to shatter, then leaving the location. The officer observed a brick inside the motor vehicle with glass shards inside the front passenger seat, floorboard, and outside the motor vehicle. The complainant was positively identified by her Texas ID prior to driving to her location per GPS. The officers followed behind and the complainant pointed at the apartment as the defendant was standing right outside of it. The officer made contact with the defendant who was wearing the same outfit in the video, and the defendant admitted to breaking the complainant's window.
Got it. Do you have the rip done? I'm assuming this complainant doesn't want to have contact with her?
We do not have, we have.
Not yet? Okay. Ms. Burse, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes, Your Honor.
I don't care what's going on in your life. Don't have any contact with this person. I'm also ordering you not to be in possession of your weapons as well.
Okay.
If I find that you're a danger to my community, it's not going to go well for you. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? Are you sure?
Yes.
Do you want to apply for a court-appointed lawyer?
If I really don't need one, then no.
You need a lawyer.
Okay, then
You're facing 6 months in jail,
then yes.
$2,000 fine, plus it could go on your record, and it's disastrous when it goes on your record.
Yes.
It's a good idea. Do you mind giving an application? So I'm going to have you fill out the application. I'll have you take a seat in the jury box. So we'll get your bond conditions. Do not leave until you sign them. And then I'll have you talk to a lawyer here momentarily. So can you file no contest, please? Please. Did you say she also doesn't have a license?
I did
I
not.
thought I heard you say that.
No, I did not say that. She has a driver's license number. I can run it really quick.
Yeah, do you mind? Because one of the things is she was left in the Kia, right? So let's see if she has a license. If not, I'm not gonna let her drive.
We're almost done. All right, Judge.
Her driver's license is out.
Okay, great.
Is page 15, Miller, come on up.
All right, good morning, Mr. Miller. Sir, you're charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The complainant informed the officer that on November 9th, 2022, in Harris County, Texas, the defendant was sending the complainant harassing text messages to the complainant. The complainant and the defendant had been in an on and off relationship and had recently ended it. The defendant would call and text apologies that he would love her. The complainant stated eventually that the defendant started conveying messages that were angry in context. The complainant blocked him in response, and then she began receiving calls and texts from unknown numbers. The complainant even asked the defendant's mother to tell him to stop calling her. The complainant stated that the night that she received calls and that night she received calls and texts from the defendant with him threatening to call Child Protective Services. The complainant and the defendant were using an app and calling and text. The defendant was using an app and calling and texting from different phone numbers, and he sent multiple phone numbers and different text messages that are outlined in the officer's report.
Gary Phillips.
Are we
Yeah,
talking
nothing.
like tons of text and stuff? How many are we
Yes, sir.
talking?
Tons of texts from different phone numbers after the complainant had repeatedly told him to stop.
Okay, I see. I'm looking at dozens and dozens. Okay. All right, Mr. Miller, I'm going to find there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person. I don't care what medium it is. I don't care if it's a smoke signal. I don't care if it's with Snapchat, WhatsApp, social media. If I find that you do, I will revoke your bond and put you in jail. Do you understand? No means no. Just, you don't have children with this person. Move on. 10,000 other fish in the sea. It's not worth it sitting in a 6x9 because of one person, right? All right. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you have the ability to hire a lawyer?
Yes.
Okay, so what we'll do is we'll give you time to hire a lawyer. I'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it and then you'll be free to go. All right, please.
Judge, that state's bond conditions?
Please.
Yes, sir.
No contact and no weapons.
All right, Judge, next is page 21, Runyon. Come
And
on
then
up.
if you don't mind, Abigail, would you mind reaching out to the person to let them know that we've placed these bond conditions in the event that she starts getting anonymous
Yes, Your Honor, we have been
to
in
let you guys know?
contact with her since the case has been
Great.
filed.
Good morning, Mr. Lenion. Sir, you're charged with illegal dumping. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 23rd, 2025, a witness stated that he saw the defendant dump a sofa on the 22-800 block of Fair Lake Lane on Tuesday, January 21st. The witness stated that he was cooking and looked out of his kitchen and saw a truck and the defendant come out to dump it. And the witness took a photo of the defendant's license plate and of the defendant.
The witness told the defendant that you can't dump trash there, and the defendant looked up at the sofa he already dumped and left. The witness stated he was concerned the defendant was going to dump the sofa at a nearby location. So the witness drove to the main roadway near his house and observed the sofa had been dumped at a abandoned car wash located at 11440 FM 1960 in Huffman, Texas, which is not an approved dump site by the Texas Commission on Environmental Quality. The witness is positive that the sofa is the same brown sofa that the defendant dumped near his house previously.
But he didn't see it.
No, Your Honor, but he did it was the same sofa, and he did follow, and then at that point, the sofa was still on the side of the road.
Yeah. The witness stated he was cooking, looked out his kitchen.
I know that he sees it. So he doesn't dump it that first time. He goes to a location, he's about to dump it, but he doesn't, he takes off.
So I would just request, this is not with us, this is with environmental. I would just request we hold off on PC reaching out to the prosecutor.
Okay, I mean, I'm willing to hold it, but you know,
I get it. I just want to make sure the prosecutor.
Mr. Runyon, just take a seat for me in the jury box, please.
All right, Judge, next is an off-docket arraignment.
I got it.
Has it up there?
Yeah.
Dave, do you have the case number for Vasana?
No, I do
You
not.
ready?
You ready?
Yes.
2549470. Vasana, come on up. Some cases.
I have it, thank you.
Right here. Has that.
You were Alan Villasana.
Sir.
Mr. Villasana, you were charged with two cases. You were charged with theft. You were also charged with racing on a highway. On both of those cases, you were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The theft or the racing?
Yeah, start on the theft because it's the earlier one, yeah.
On January 1st, 2025, officers were dispatched to a shoplifter call at a Target in Harris County, Texas. The complainant, the loss prevention employee, called the officer regarding a theft in progress at the location and observed a Hispanic male wearing a tan hoodie and black shorts making a selection and removed a security tape from a JBL speaker box and placed other products inside a shopping cart. The complainant proceeded to keep the surveillance on the male and observe the defendant proceed to exit past all points of sale without any intent to pay for the items. The officer reviewed the surveillance and observed the complainant make contact with the defendant at the front entrance and attempted to retrieve the stolen items, and the defendant proceeded to leave the Target and enter a black Chevrolet Spark. With the assistance of a license plate reader and TLO, the officer determined the motor vehicle to be driven by the defendant and obtained a Texas driver's license, which the officer believed completely matched the Hispanic male captured on the surveillance footage. The total taken was $499.03.
Okay. On the racing, please.
Yes, Your Honor. On March 15th, 2025, the officers observed a black Toyota Camry and a silver Chrysler sedan traveling at a high rate of speed on the main lanes of the Katy Freeway. Officers attempted to catch up to the motor vehicles traveling 120 miles per hour to keep the motor vehicles in sight, but both motor vehicles were still outgaining speed. The posted speed limit was 65 miles per hour. Both the defendant and the silver Chrysler were racing in competition side by side at points, with both motor vehicles accelerating at a high rate of speed, attempting to outdistance and outgain each other. While the defendant and the Chrysler were racing, they were making evasive lane changes and failing to signal lane change, cutting off multiple motor vehicles to get around traffic, causing victims with their motor vehicles to take evasive actions to avoid collisions. The defendant's motor vehicle at one point drove on the right shoulder to pass vehicles in the right lane and was in front of the silver Chrysler. A traffic stop was
So
initiated.
driving on the shoulder
Yes,
to
on the
get,
shoulder. A traffic stop was initiated and the officer made contact with the defendant, who was the driver. The defendant admitted that he was racing with the other vehicle and that this was not his first time racing, but his first time arrested, and that he would have ran from the officers if he had more gas in the motor vehicle.
Mr. Villasana, I'm going to find that there's probable cause to go forward on both of your cases. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke the bond on both of your cases and I'm going to put you in jail. I'm also ordering you now not to drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
How long?
While this case is open, and if I find that you do, likewise, it's not going to go well for you. Do you understand?
Yeah.
Can you print me out more affidavits, please? You're not to go to any target whatsoever as well. If I find that you pick up a third case, it's really not going to go well for you. Do you understand? I'm going to do everything in my power to protect my city at all costs. And if that means putting you in jail and making your bonds high, I'll do it in a heartbeat. Do you understand? Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
I didn't have a job right now, so I can't.
Okay. Deputy Miranda's going to give you an application. I'll have you fill it out and I'll take a look at it with you. Hey, I'm not done talking to you. I'll have you take a look at I'll have you fill it out. I'll take a look at it. I'm going to have you sign a receipt with Victoria. I'm going to have you come back because I'm going to have you sign an affidavit with me today, promising me you're not going to drive. And then you'll get with Fleischer for your bond conditions.
I won't be able to come back. I don't have a right.
Figure it out. I'll get you a lawyer and we'll start talking. But I don't want any more problems. Do you understand?
No, I haven't been in problems like 5 years. This is the first time I had a case since 5.
So, please.
Go ahead and sign for your receipt, please. All right, as you know, what was that? Sorry.
Frederick, who do you got, man?
Hello, Judge. Good morning.
Hey,
Hey, Judge, this is a felony pending case, and you brought me back because I guess the case is getting old. But on my last setting, I told you I was submitting a mitigation packet to the felony court, and you said I also got submitted to the misdemeanor court as well. So essentially,
what are we talking about?
I'm sorry, his name is Smiley, Theory Smiley, I believe his name is.
Have you turned in the mitigation packet?
No, I was going to do, but well, I have it, but I just haven't turned it in yet. But what I wanted to clarify is, well, I want to turn into the felony first. I could basically do it the same day, I'm assuming. But this case is it? Do they just get a copy of the felony mitigation packet, or do I just target a mitigation packet towards this misdemeanor charge?
About a week ago, waiting for a response.
What do you want?
Me?
Yeah.
Basically, I'm trying to get him a PTI in felony court.
Have they offered that upstairs?
No, but they told me I could submit a mitigation packet, and they gave me a date.
Your case is 230 days old though, Frederick. So it's time to start getting, like how soon are you getting it to where it's done?
It could be done today. I mean, I could submit it today. I just wanted
Are
to
you
get.
prepared to submit it today?
Oh, honestly, I mean, I could, yeah, but I'll probably have to submit it by over the weekend. Because I got all the stuff I need. And it's not that
So
difficult.
I don't want to, I'm not doing any more long research just because it's as old as it is. I mean, I'll set you
Understood.
up a couple weeks, like 2 weeks. Submit it as soon as you can so that we can just try to get a response, huh?
Well, you
Please.
have my word on that, Your Honor.
Okay.
Okay.
Give me a second, I'll get you there.
Sure.
Thank you so much.
You're welcome. Yes, Judge.
Bottom of page 23, submitting a mitigation packet, both here and in the felony case. He said by Monday, so like two and a half weeks.
Fair.
Howard?
You promise, right?
I promise, Judge. Yeah, it's not like I can hide from you.
Pinky swear.
There, Pinky. There you go.
Two and a half. Good. I mean,
Okay, how's April 8th through the 10th?
April 8th to the 10th.
A Tuesday or Thursday. Either one.
That
It's
is
up to Victoria.
the 8th and the 10th is 8th is a Tuesday and the 10th is a Thursday. I'm assuming you work farther.
You can make
Or do you want the
8th
same day as
so-
a felony?
Yeah, well, that would be preferable, I should say.
You want to do the same day as a felony?
Yes, because I can go finish that. At least you'll know I'll be there, so I have to check
Okay.
in with you to make sure everything's good.
Required appearance?
Yeah.
He's required today.
Your dude's not here today, he's supposed to be here.
You know what? I don't know that I informed him.
All right, I'm setting it for bond forfeiture. If he's not here next time,
There you go. I appreciate
All
it.
right.
I can do that. I can make up for that. You give me a chance.
okay, man. We'll see you
Thank
soon.
Dad. I'll
Take
take
care.
that. All right, take care. Bye-bye.
Hi, Sylvia.
Good morning, Your Honor.
You got it.
I'm appearing on behalf of Mr. Guillermo Gonzalez.
What's the last name?
Gonzalez?
Gonzalez.
Gonzalez.
Okay, it's getting old. What would you want to do?
Judge, we submitted a mitigation packet on this case on March 11, and then they asked us to submit also the application because I think they changed the procedure. I was not aware of that. So I submitted the application and I'm waiting for them to make a decision on the request for the DWI.
What say you?
Sorry, Your Honor.
Do you have a response on Gonzalez as far as the PTI? Approved, unapproved?
This morning, I see. No, we do not have a response. We got everything in on the 17th. I got an
Oh,
update this morning.
you just got it.
The application was sent on the 17th, yes.
Got it.
I just got we sent the follow-up this morning.
Don't worry about it. I mean, if you got it 3 days, that's just not enough time to look. I mean, we'll give you a week or so, you know? I'll set it off a week for them to take a look at it and see whether, it's yay or nay. Okay?
No problem, Your Honor. What day do you want me to be back in court?
You pick the day. I don't care.
Next
Whatever you want.
week? Can it be next Thursday?
Done.
Perfect. And do you want me to be present in court with my client or is his presence?
Yes, right. No more waived appearances after that.
Perfect, Your Honor. We'll be there on Thursday, the 27th. Thank you, sir. You have a wonderful
Okay.
day. May I be excused, sir?
Yes, ma'am. Thanks.
Thank you. Appreciate it. Thank you.
Some more time for the mitigation packet, but the. Okay. Figure out.
Hi, Trevor.
It's not for the. It's not for the.
So do you have to share?
Oh, yeah.
Yeah, I think so.
Victoria, full of affidavit for the first, no, thank you.
Counsel, do you need me? Come on up. Okay, I'll sign it.
Mr. Morale, oh, you did?
No, I will.
Okay, yes, and I did speak with the previous attorney, Mr. Laredo, and he said he had no objection.
Okay, great.
So then, thank you.
Is it on docket today?
Yes, it is, and I just turned
What's the
it
last
in.
name?
Last name is Morales.
Morales.
Justin Morales, first name Nehemiah. He has two cases. He just picked up a somewhat new one, I believe.
Is he in custody?
Yes, he's in custody.
Okay, yeah, whatever you want.
Thank you. Thank you.
Hi, Judge.
Good morning, Your Honor. May I approach?
Please.
How are you this morning? Good, good. I have an interesting situation, a little bit unfortunate, but it's not something that can't be fixed.
Okay.
There was a case in here, Michael Jones. I would give you the cause number, but I'll explain to you first, and then we can look him up. But Michael Jones pled to a Class A, but it was actually a Class B. All right.
So we can do a nunk.
Well, we thought that we could. I mean, I'm not sure if that's an option or not.
I should so.
I'm hoping that it is.
You can do anything you want until someone says no, right?
Yeah, right, that's right. I don't think anybody's going to object. We're bringing it to you, so we're not objecting to it. And of course, it is the case that was handled by the Public Defender's Office. And
Okay, so you're for the state then?
yeah, absolutely, Your Honor. I'm
Sorry.
Senior counsel for the district attorneys.
I need to get the defense lawyer then. I thought that you were
Okay.
defense.
All right, I apologize for not
It's
introducing myself.
okay. Can I have the cost number? Do you mind?
I will give you the cause number. It's 255-4843-0110.
Let's see. Okay.
And so my position now is senior counsel in the district attorney's
Okay.
office.
Let me get a hold of Ms. Strong real quick, and then I'll have her come down, and then we can talk and figure out how to.
Just coordinate it with their coordinator. Would you like me to?
It's up to, I mean, I've got her phone, and she's here every day.
Okay.
So let me see if she's here, and then that way, if you give me just a couple moments, I'll see if she can run down.
Great bow tie, by the way.
Case for her on docket, but I'm not,
Do you have something here
I
today?
didn't think so. I was running the docket.
She's really great about showing
Yeah,
up,
she's-
so,
We
she
always
has the
love
case
that,
full.
don't we?
Yes.
She's aware of it, you're not, so.
All right, I'll stand down, Your Honor. Thank you.
Yeah, give me 5 minutes. Let me get a hold of her,
No problem.
and then,
Yeah.
Okay, no problem. I was.
why not?
Because the defendant got released yesterday, so we're gonna do a motion for the trial and. As I talked to the supervisor about this, because we got the email about this case. And that the plea already went through. Judgment accepted, the charge, like, he already finished his 10 days in custody, so 39+3 on the judgment. And he went in 10th, he got released yesterday. So my supervisor was saying he wouldn't be able to do it now because it was a state's issue or wasn't amended before the plea was taken.
Council for reset?
It's usually enough is whenever there's a clerk there, but they let me know that there was nothing.
Ms. Strong? Hey, it's David Fleischer. Hey, were you here for? No. Can you pop in Zoom later? Here's the deal. So, no, we have a guy that we pled, Michael Jones. I don't know if you remember. And we pled him, and it looks like the plea was done wrong. It was pled, it either. Hey. Right, right. So we need to talk about that next time. Judge.
He's good for that. Oh, I'm sorry, Your Honor.
Hey, hold on, Errol. I'm going to put you on speaker, okay?
Okay.
So I have Zoom available. She can pop in via Zoom, or would you rather do this in person, maybe like tomorrow?
No, whatever is most convenient. We just want to make sure that it's done, done right, whatever.
So what would happen is the new trial, if we did a new trial, granted, what would happen, it would revert the case back to original status, A and B or A and J.
We can't do a nunc
And then
because
we
a
do
nunc
another-
is a clerk error.
That's what, yes. And so a new trial, fine, and then we can change whatever, I don't know.
So, yeah, so let's do a motion for new trial. I can grant it. And then, I mean, do we have to do the plea all over again where we bring
Yeah.
him in?
We have to do the plea all over again. I don't know the status, but believe me, it's not going to be a problem. You know what I mean?
Case credit now, we did 39. for
I don't think the time is a problem, is it might be getting a hold of him. That's the issue, because
He got released yesterday.
I know, but trying to get a hold of
I'm
him.
not going to let it sit on your docket.
Okay, got it.
If you read behind.
I got it,
you know
I got it,
what
I
I'm
got it.
saying?
Okay, I'll grant the new trial. Do you want to file it?
All right, that's fine.
Do you want to file it and then I can grant it?
I don't, can I follow it as a
And that's
state?
what I'm, that's have to do it, or we have to do it. I'm fine with doing it. I just didn't know it. Are we allowed to?
I don't know.
I
I don't know who files it.
I'll look into that. If the defense isn't going to do it, we're certainly going to.
Okay, so Ms. Strong,
Yes,
I think that you might need to file the motion for new trial.
okay,
I'll grant it. It reopens the
Okay.
case as if it's just, it opens anew. And I think that at
Mhm.
that point, they're probably gonna end up just kicking it. And then we're all said and
Dismissing
done.
it?
Yeah,
okay.
to undo the
I'll
mistake.
file that today.
Cool. Okay. Done.
Thank you, Judge. And then Judge Fleischer, did you need me to come in person tomorrow?
No. Just, I'll text you the cause number so that you have
Oh,
it.
yeah, once breaking up.
I'll
So yeah,
text
I'll
you.
file the motion for new trial, and then what else do I need to do after I file the motion for new trial?
That's it. Just let us know you filed it so we can put it in the queue and I'll sign it and I'll grant it. And that's it.
Thank you, Judge
And then we'll
Fleischer. It'll
let
be
you
in the
know,
queue.
and I can email you to let you know that it's all said and done. But thank you for bringing it
Perfect.
to our
It'll be
attention.
in your queue, by noon.
Okay. Well, no, Ms.
I
Strong,
appreciate,
take your
thank you for
time.
calling me, Judge.
Really.
And also, okay, I'm so sorry. Okay, so I
Look,
saw
look,
that.
but let's not, don't worry about it. Everything's good.
Okay.
Don't worry about it, Ms. Strong. You're doing great. Okay?
Thank you, Judge.
Thanks.
Okay,
Okay.
I'll file it. Thank
Bye.
you. Bye.
Okay, thanks. Take care.
Thank you. Yes.
Judge number 2.
Judge, how are you?
Hey. Are you ready?
May we approach it?
Please.
Thank you.
Good morning.
Morning, Judge. I have a gentleman by the name of Kayuba Thomas who is with us today. He has a warrant. It's kind of questionable, but nonetheless, he does, and he wanted to turn himself in.
Okay.
I wanted to see if depending on probable cause, if you did set a bond, whether you might consider a PR bond because his medical condition.
Don't worry about it.
Gotcha. Would you like him brought up,
Just-
Judge?
Please.
Okay. Mr. Thomas?
Yeah. Judge Powell, do you have the cause number by chance?
I think Abigail has it.
I do have it, yes, Your Honor.
Here, what is it?
Ready?
Yeah.
It is 2555058.
Did you get it?
Yes, it is.
Yes, Mr. Thomas. Coming up, Mr. Thomas. Good morning, sir. Sir, you were charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
On February 6, 2025, the officers interviewed the complainant, who stated that on January 18th, 2025, the defendant came into the 5-minute oil change located at 747 Gary Ashford Road in Harris County, Texas, to have maintenance performed on his vehicle. The defendant let the complainant perform a cabin check on his vehicle, so the complainant got inside the vehicle. The complainant and defendant then exchanged a verbal exchange because the defendant was upset that the complainant was inside the vehicle. The complainant's manager interviewed and attempted to de-escalate the situation, and the defendant told the complainant's manager, "I'm going to come back here, you better correct him before I come back here. I'm going to come back here and I'm going to finish him off with a gun. I will fucking come shoot you all. I will do a drive-by." The complainant confronted the defendant and told him that he was not welcome back. The next day, the defendant was captured on surveillance footage at the location speaking with the complainant's coworker, who informed the defendant that the complainant was not at the location. The defendant went into his armrest and the witness stated that the defendant went into his armrest and he pulled out his gun while uttering the words, "Because of what happened yesterday, I should have shot his ass," referring to the complainant. The defendant stated, "I'm going to come every day until I see him."
And Judge, that's simply not true. In fact, I have his.
Remember, this is a probable cause.
I understand.
You start getting into more stuff. I mean, my only concern is, was there a terroristic threat, right?
Exactly,
And
exactly.
I don't know, it looks like there were potential multiple threats. So which one is in the charging instrument? Is
I think the one alleged to have occurred
on the actual day in question when everything,
I can look and
Yeah.
double check.
because what I have, Judge, is just a receipt from when he paid. And because of the way he was treated, they gave him a $20 discount. It shows on the receipt as well. So, he had told them, "Don't upsell me, don't upsell me." He comes around the corner and the guy's in his car. So that's why they gave him the discount on the receipt.
but I mean,
Even so,
Did-
Your Honor, a discount when happened.
No, I understand.
And just to clarify, it is the first threat on
first
January
threat.
18th.
Yeah, I mean, it's,
It is what it is. I understand.
so Mr. Thomas, I'm going to find that there's sufficient probable cause to go forward with the case. The only thing I'm going to ask you to do is don't have contact with the complaining witness, don't be in possession of weapons, and don't go back to the 5-minute
5-minute oil change.
Yes,
the
sir.
5-minute oil change. That's all I'm asking you to do, really. Just don't have weapons and don't go back, okay? That's it. As long as you can.
Also ask for no contact with the complainant because they don't-
Of course.
Already. Anything further, Judge?
No, we have to do bond.
Oh, I'm sorry.
Um, Might bring me out of PS. Sorry.
It's already set at $100.
Oh, it is? Okay, so I don't need to. All right. So, Mr. Thomas, I'm going to grant you a PR bond today. You have a bond set at $100. I'm going to grant you a PR bond. All I'm asking you to do is just don't pick up any new cases. Just be nice. It's not hard. You've got a great lawyer here. Listen to him. He'll take care of you. I'll waive your appearance because you have a lawyer. You don't even have to come back. Just stay out of trouble and that's it.
Okay, thank you very much, Judge.
So I don't let him, I need you to sign a bunch of paperwork. We have bond conditions that we're going to create. I need you to sign them. Do not leave until you sign our bond conditions. You'll have to meet with Felicia for your PR bond. And after that, you'll be free to go. Okay? All right.
All right, thank you very much, Judge.
And then, and Judge Powell, do you
Yes, sir.
attorney of record, please?
Yes, sir,
We
certainly.
have them over there in the tower.
Okay, thank you.
Judge, I need the cost number.
2555058.
058.
Yeah.
Thank you. All right.
Marcos, you ready?
Yes, Judge, ready for a plea?
Yeah,
Mr. Salvador, may I bring my client?
please.
Salvador?
Buenos días. Nosotros hemos adversos como una plática.
Good morning, Mr. Salvador Mahia. Sir, you are charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and/or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You need to understand that this DWI will go on your record. It will be there for the rest of your life. It's even there after you die. This is important because if you get pulled over in a car, an officer comes up to your window, they see that you have a prior DWI and they smell alcohol on you, or they smell anything funky, it's probably not going to go well for you. What we're doing today, the proverbial slap on the wrist, will not happen again. From now on, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
You're giving up the right to trial, held witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this. Do you understand?
Yes, sir.
You still want to do this?
¿Cómo quiere ser? ¿Quiere ser este condono? Yes.
Is it true
¿Es
or
verdad
untrue that you
o
had
no
a
es verdad
five or
que
above?
tenía un dono 5 más? ¿Verdad o no verdad? ¿Verdad o no verdad?
Sí. ¿Verdad o no verdad?
True.
Answer. All right, sir, I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I am going to suspend your license for 90 days.
Yes.
Do not drive until you get a license. And I'm going to tell you now, I will waive the $4,500 surcharge that normally applies in this type of case because we all make mistakes. But if you continue to make mistakes where you endanger other people's lives, a second DWI, not only is a minimum of 90 days, but it's a $6,000 surcharge. Do you understand?
¿Lo entiende?
Yes, sir. All right, good luck.
Thank you, Judge. Have excuse.
Thank you.
Aquí.
See you.
Morning, Your Honor. How are you?
Right now, how are you?
Yes, Judge. Yes, Judge. Yes, Judge.
Who you got?
Approaching on Joe Brandon, Your Honor. Mr. Brandon, his appearance was waived, but wanted to discuss bond conditions with you.
The new driving one.
No, Judge. Actually, no. You made it clear on that one why you would.
I don't even remember, but tell me, what do you want?
There's a reckless driving, but there's other things going on. You also put him on a monitor with a curfew. It has been over 3 months since this allegedly occurred on December 15th. We are not arguing the no driving part of this. We understand why the court's doing that. But with regard to the curfew and the monitor, we'd ask that the court consider removal. Well, I mean, if we take away so he can work.
Does he work in the middle of the night? Does he work in the middle of the night?
Judge, his his proposed shift that he's trying to get is going to carry over into the night hours. I mean, I would ask for amendment of the curfew, but if we get rid of the curfew, there's no point to having the monitor.
So let me know if he does get that, come back and we'll talk, and I'm happy to amend.
Okay.
You know, he's been doing good, I'm assuming.
Yeah.
Okay. Yeah, I'm happy to work with you for it. You know, if he does do it,
Do we understand the no driving? I'm not going to ask you about that
it's
again.
okay. But if he does get it and he needs those work hours, I'm happy to do it.
Judge,
Yeah,
appreciate
okay, for sure. Counsel.
Good morning, Your Honor.
Hi, good morning.
Rivera Mendoza. There were some issues with his machine, Your Honor.
Come up, Mr. Rivera Mendoza.
Sorry, Your Honor, I didn't know the interpreter. Mr. Rivera speaks English, Your Honor. He just.
So the first thing I'm going to do is I'm going to send him for a drug and alcohol test right now.
Okay, Your Honor.
To send him for a test to see what, if anything, he's going to test positive for. We'll have him come back and then we can deal with the bond violation.
Correct, Your Honor. Yes.
Yeah.
Yes, Judge.
I'm sending Mr. Rivera Mendoza for a test, please.
Yes, Judge.
Does he go back to the box, Your Honor?
He should only need to sign conditions.
Thank you very much, Your Honor.
But he has to come back. He
Yes,
has to come
yes.
back. Okay.
You're gonna
Yeah.
I just cut out. He has a scram. Do you need to sign anything to remove that?
No, once they see the order has been done, he just needs to go to, I thought the seventh floor? No. Ask Felicia, she'll know more.
Okay, thank you.
But once the order entered and they see it, at that point, though, he can go. I just don't know where.
Oh, sorry. Thank you. Council for recess. Council for reset.
And then it's sometimes fun to hear out. But you're cool with that.
So that's kind of where we're
Hey, JP, ready?
I've got Mr. Good morning, Judge. I've got Mr. Disaki.
Okay.
Last name Dissaki.
Yeah.
You were rolling him day to day. He submitted all of his information for mitigation. We submitted it to the DA. They're reviewing it for a possible DWI PTI.
Someone different that we were doing that with.
Oh, okay.
This wasn't someone else. This is someone different. This is just his case is old.
Oh, it's old.
It's not the one that you're thinking about.
Okay, maybe I'm eyes crossed, but
is everything in?
We got the application yesterday, so I'm gonna get it turned in by the end of the week if I can. We just got.
Is he giving you everything that you need?
He's giving me amount of mitigation, like in record time, in 2 days.
Okay.
He gave me everything.
So you just need
I
time.
just need to get it in.
When do you want?
Can I resend them next week? I should have it in
Yes,
and
I'm okay.
give you an update, Judge.
That'll be turned in by then.
I will, Judge.
Okay.
It's on me at this point. Can I waive my client's appearance? And I'll just give you an update on, thank you, Judge.
Sure.
Your Honor.
Well, I have a drinking problem.
You, well, can't seem to stay. You can put yourself in. No problem.
It's impossible to keep the soup clean. Problem. Cheryl Higgs is not county criminal court. I don't know. Oh, I'm sorry. I didn't even see. Please.
I'm approaching on laws.
Okay.
It's the last name. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
All right, this is.
Don't think there's PC?
Laws.
Okay.
Yes.
You don't think there's PC?
I don't, looking at the dims, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case and I just got appointed on it last month. So
Did you already approach on PC on this?
I have not.
Don't worry about it.
And I'll just be honest, Judge, I had assumed because of the age of the case that PC had been done. But
Of course it has been.
right.
But there's new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through 2021 case. Thanks, sir. Look. All right. On October 5th, 2021, the officers were dispatched to a DWI call. Excuse me. Activation. Okay. Officer were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes while making a turn on the highway, heavy traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, odor of an alcoholic beverage, and poor balance, and a order full of quiet, please. Cold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the HEN, a 7 out of 8 on the walk and turn, and a 4 out of 4 on like stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address. And there's no reason given in the DIMS for the stop.
She read something different.
That was
Yes.
not in the DIMS.
That seems to be from the offense report.
Sure, but I mean, what's,
But I thought for PC, we just used the DIMS because that was sworn to, and not getting into the.
show me where it says that. I don't know of any rule that says that it's, PC has to be done on just the dim.
Okay,
You know, I don't. If you can direct me to something,
okay,
but I've
and that just may
never,
be my misunderstanding of a
yeah,
policy.
I don't. And I've heard this before.
Okay.
Right, but I can't, I've never seen anything where someone has ever directed me to saying, hey, PC is only,
Well, it's
has to be just on the dims, you
because the
know?
DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into.
Sworn document too.
The offense report's on a sworn document.
Thank you very much. I mean, I guess, Your Honor, my thing is it's a public record that they're using DIMS taking the offense report. And also, I have never seen a rule where we have to rely solely on the DIMS for probable cause. It's probable cause. In fact, when we go to the grand jury, that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence. And that's probable cause.
Yeah, I don't know. I don't think that, I mean, let's look, because I don't know, you know?
Okay. I'll stand
And
down.
I'll,
Go check with
Sure.
Ms. Roberts.
Hey, you ready? Come on.
Yeah, I just want to approach on bond conditions for Mr. Bardon.
Okay.
Adrian.
Oh, so you got appointed Mr. Al-Bardon?
Yeah.
Great, okay.
He has a residency restriction to stay away from his father's house. That's where him and his siblings live. And I want to approach you about lifting that up to no harmful or offensive contact.
And I'm okay. So he's, Mr. Al-Bardon, come on up. Your lawyer wants me to change the conditions so that you can go back to the house. But I want you to understand that if you have a very tumultuous relationship with these people where you're always butting heads with them, it's not going to go well. I don't want you to have any threatening or harassing contact with them. What is threatening or harassing doesn't matter what you think. It is what they perceive. So if you go like this, is that threatening or harassing? It most certainly is, and it can land you back in jail. Do you understand? So if you cannot be nice and if you cannot get along with brother and sister or dad, be very careful. Because if I get wind that it's not going well and that you're threatening or you're putting anyone in danger or you have a weapon, I will put you in custody. You understand? Okay. All right. I'm done.
Thank you, Judge. I'm excused.
Thank you. The only, so, Mr. Al-Bardon, the only thing I'm taking off of the protective order is the residential restriction. Everything else in the protective order stays. So if you threaten them, if you harass them, they can charge a new case on you. Do you understand?
Yes, no.
Okay. All right.
I will convey that.
And if you can file, no, now we need,
State bond condition.
yeah. So, Mr. Reedy, we need new bond conditions. He can't leave just yet, so we need him to sign no
Okay, I
threatening
thought
or
you were
harassing.
wait right there, not to leave.
Okay.
Yeah.
States.
Hey, Herbert.
Okay.
How are you, Judge?
What's new, man?
Same old.
You can pick a day.
Well, I have Monday and Tuesday are not good for me. Wednesday or Friday of next week is fine. I mean, I have a few days every week. Just
All come together for the meeting of the minds.
I think it's from what it sounds like, our officers we need two officers. One is,
Yes, one is unavailable on Wednesday and the other officer is unavailable on Thursday and Friday. I've reached
So
out
go
to
into the
both
next
of-
week.
Yes, yeah, okay.
I don't
I've reached
care.
out to Both of them to find out their availability for next week. I'm just waiting to hear back. The next week after that.
Okay.
Yeah.
okay.
No stress, man. We have enough drama. Just pick a day. I don't care.
I'm not
Just
looking
make
for
sure that, like, I don't want to keep doing this stuff. This is like, this is the last time.
Before we said, hey, come next week.
If we set this for the next hearing and one of the officers comes back and says, I'm sorry, I can't do it. I don't give, we're going forward without that. All right?
All right.
Whatever you want,
All right.
of course.
Sure.
So that information you were telling me about for the VPO?
Not quite, we need it.
Cheryl Diggs was the magistrate that signed the original bond conditions.
Right,
Got
but
picked
this is,
up.
pla-
Would you like us to amend it?
no, it's not you, it's them.
Yeah.
So let me, I'll bring it up to them in a second.
Okay.
Ralph,
Oh, yes, sir.
hey,
I've got Mr. Basie and the state would like to evaluate it. It's an old case, Your Honor, but they asked if we could reset it, which I'm in agreement.
this is an interesting one.
Right, it really is.
A week. We filed for a week.
Yeah, sure, yes.
Do you have an offer on the case?
Just want to do one, just the,
Yeah.
I just want to do one little case law.
Not a problem.
thing. I think
Is discovery complete?
discovery complete.
You've got an offer?
I think we're gonna be able to resolve this case.
Okay, so I guess set it for next week
All right, sir.
and then we'll come back
I
and,
just want to do one more little case law.
no problem.
Sure. Thank you both.
Hi, Ralph.
Thank you.
Judge, for Al-Bardon, their state's conditions, correct? Oh. I know, I heard him say it's your, next.
Hey, Anna, come on. So you're saying that it doesn't, the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement and speaking with Ms. Rogers, we're looking, but it's not,
And I'm looking to.
okay.
I am too.
There was a class action lawsuit and as part of the settlement, the agreement was that Harris County would use the DIMS to support
Okay,
PC, but we're getting that all together.
me too.
Okay.
For the 26th, March 26th. Want to call him up and sign? Yeah, you check, he's out there somewhere.
Mr. Basie?
In just a minute, it's not ready. You'll sign in just a minute.
You said pursuant to the consent decree, is that what you said?
There's a class action lawsuit. It's Lotus and Elgin versus Harris County and.
Okay, hold on.
Southern District of Texas. Okay, go ahead and sign, please.
What is it?
Corey Millen? Yeah.
All right, there you go. You're good to go. You're welcome.
Was there a result for that?
Yes.
Or is it in action now?
No, this was some time ago. So this was before the DIM summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Court. And out of that lawsuit, it was just allegations of Fourth Amendment violations because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an other information. So I think it is a Fourth Amendment issue.
But I'm curious, so I'm curious, for PC purposes, can state use an offense report to supplement a DIMS? Or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
Well, the four corners of the DIMS is what's sworn to, the offense report is not.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's, in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the office report, he is committing a crime. So I mean, I don't say that the office report is not sworn to. It's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false,
Right, but perjury's
an official document?
a different crime.
No, but it would also under the purview of filing a false, you know.
Well, Judge, if an
Filing a
officer
false-
came into court and was asking for you to sign a search warrant, and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea, because this is a warrantless arrest, there has to be someone swearing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest, it was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
Was there blood in this case? Right. Okay, give me 5 minutes.
Okay.
Huh? Okay.
If it's okay with you, we'll take
Can
a
you
look.
show them?
yeah, that's fine.
I'm done with everything, I just, because you missed state's conditions. So I just need to instruct them on how to get like the version.
Awesome.
No. I. Until you did.
Okay.
And it's not all.
Got you.
Morning, let's go. Library to the right top, but I'll be like, remember what I'm pretty great. What is it? It's further in the never valid. Is out, Gene, I'm just. I mean, that's why this is the chance. Sorry, no one's arguing about My birth and overtime life. Yeah, you gave me to
Okay. And first.
Yeah, she gave me first. Okay.
I have a motion.
Yeah. I'll have to have it.
You can manage, you can I speak? They are. My brother's going to. He support, I mean. Council for reset. Mr. Dixon, you just got a new one.
Okay, great. Thank you very much.
But nobody's posting it.
No, it just remained according to. Is the code verse, this verse, coming to me? Yeah. Alex. Alex.
No, oh, wait, we're going to.
Yeah.
It's just the principles that you agreement on one of Yeah, the intensity for you, that's either available or. No, I haven't seen it.
So I mean, I know. Like when schools come up, but yeah. You're gonna be able to come.
Okay.
Already sent an application to this place.
Oh, okay.
I'd stay. I'll leave you guys like.
Oh, the email. Look, it came to me as soon as I found out. We gotta kind of figure it out.
Yeah. Figure out, because we knew like it wasn't hysterical. At least that kid said.
Things might, it should have been a motion to amend.
It should have been, yeah, that's the issues we found, like accuracy and stuff.
Yeah.
Yeah.
So technically what's gonna happen now is we're just gonna new trial as well.
And then we're gonna discuss that's.
Yeah.
I'm sorry.
Okay.
Yeah.
All right. Okay.
I was thinking, no.
Oh, wait, I did it.
Why
Disregard.
did you do that? Was that the one?
That's with the, like, how you said, like, no, and it was your first.
Email.
Yes, now.
So she said.
Oh,
Oh, yeah, no.
sorry, I was. No, I looked at your.
Okay, I thought it was already said.
Yeah.
Thank you.
Technically.
Hey. I'm glad it's bad. Yes.
Sorry? It's not released. So maybe refresh. Oh, I just released it this morning.
Oh,
Yeah.
Yeah, it may take a couple hours.
Oh,
It just popped up.
Okay.
Oh, sound. Yeah.
Oh, my God. I have an email. You got it?
Yeah. So there were two out-of-town temporary case numbers, Jen, yeah. So there should have been 2 or 5 cases initiated.
Yeah.
That wasn't embarked. So they initiated the new case, 4 or 5. So now we're public. They said that they. We emailed it to them, but you get the time. Uh-oh, is that? That's it.
It's kind of.
It's all right. I'm here. Can you get the notice instead of buying for the $1,000 and it's back? Okay.
Yeah. I had a class. I saw her. You may want to go right now. I don't know if the vehicle's on. Yeah. You know, when I went to the Cambridge, it was like 3, I mean, all they do is patrol that record. Yeah.
Hey.
Last name is Bledsoe.
Bledsoe?
Bledsoe.
Okay, you want to bring him on? Are we going on the evading and the terrorist act that's going to be dismissed? Good morning, Mr. Bledsoe. You were charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're going to dismiss your terroristic threat in exchange for your plea on the evading arrest. You need to understand that the evading is an enhanceable offense. This is going on your record today. It'll be there forever. From now on, if you ever run from the cops again, you'll be facing a felony charge, years instead of days. Do you understand? Not only that, it's a minimum now of 90 days for any new cases that you pick up in here. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it stays on your record forever. Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'll sentence you to the agreement. If it's enhanced, it'll be abandoned. Good luck, sir.
Thank you, Judge.
Anna.
I'm working with Mr. Gladstone.
Anna,
Oh,
you ready?
yes, Judge.
Mr. Laws, come up.
Because you're gonna head down to the first board of elections, and then him with Mr. So they do it for today. So put down there, you can help with it.
We have court orders for a reason. And when you don't follow court orders, bad things happen. Do you understand? Yes. You were ordered to get an interlock and you didn't get it, or a portable device. And you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
I think that we are, you know,
Sorry.
it's okay. No, and I think you're right, you know. We were going through the lawsuit and, you know, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to, you know. I want to stick with the agreement that the county came to with the district attorney's office, you know?
So, not saying this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to say, it has to have all the elements of the offense to go forward. The reason, I mean, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because shit, you might get like 15 supplements.
And here's my question then for the board, and with, I'm not saying we do this in this case, I'm just saying for cases going forward. To me then, does that then behoove, let's say we can't take it to grand jury? I mean,
You can, of course you can.
So
just because I find no probable cause on something, if you want to go indict it, go do it.
Right. Okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them. As far as me, I'm going to just hold to the standard that we agreed with the county and the lawsuit.
Yeah, I'm just, and this is for my own.
And look, you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you, Judge.
Oh, really?
I just, so we wouldn't be held to that same
You need
standard.
you need to do what you think is right.
Okay.
Like I'm going to do it, and like she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. Not everybody is. Which is good.
Thank you.
God love you. All right. Hi, Shreya.
Hi, Judge.
Oh.
I'm Miss Lovey.
Okay.
So I wanted to address the BDR.
Where is Miss Lovey?
It's right there.
Come up, ma'am. So here's Shreya, here's what we're going to do. I'm going to send her for a drug and alcohol test now.
We already did. She came back negative, Judge.
Oh, great. Good job. But if you miss again, it's not going to go well.
So
It is your responsibility to let Shreya know if you're going out of town, if you have some other obligation, because we can always work something out. But I'm not going to continue to do this. If you miss again, it's just not going to go well for you.
So Judge, that's what we want to talk about. So when I was first appointed to her, Ms. Lovey talked to me about her work schedule. And I said, look, let's just wait and see what happens with the UAs. If you get called in for a UA, but you have work, I don't want you to lose your job. I told her that. Yes. So
They give you a sufficient amount of time to come.
same day.
Yeah, there's 6 hours.
Yes. So she's a behavioral technician at Action Behavior Center.
Yes.
And she cannot take off work.
They penalize me.
So, and do you want to talk to the judge about that?
Yes. I bought some printouts as well on my work's attendance policy. So we have like a 2 weeks ahead of time type thing. They'll let me off. I had to beg and say it was like a life emergency just to get Thursday. I also have asked before because I remember the original court date was for Tuesday, the 18th, I believe. And 2 weeks ahead of time, that court date, I wasn't scheduled to appear. And I said, since I missed that UA, would it help for me to appear in court that day, even though I'm not required to come, to show that I'm okay with appearing to test? Testing is not something I'm trying to avoid or anything, but if I can put, time and effort into make my appearances, be here, and also keep my job security, is there a way that we can balance those two things? Because I have no problem showing up in testing or anything like that. I also live in Humble, Texas. So traffic times, I get off work anywhere between 4:30 and 5:30 every day. And I did bring some printouts just in case that's needed of our policies and everything.
I'm not going to take off the fact that you're not supposed to use alcohol or drugs.
Right. Absolutely. But is there a way we can schedule her testing? Even if you want her,
And that defeats the whole purpose of it being random.
I know.
Because that's how we catch people. If you know when the test is going to be, it defeats the purpose of it being random. So why do we do this? Why don't we just work something? If you get called on again, call Shreya, and then Shreya can come to me, and then we can work something out somehow.
Okay, and every single time I will need your work schedule.
Yes, and I have printouts
So
from the
just
missed date as
send
well.
called on, let Shreya know. Shreya can come to me, and we can try to work something.
Okay.
Okay, because I don't know, you may not get called again. I don't know. You probably will because you missed now, right? But just if and when they do call you, let Shreya know and we'll try to work something out. Okay? Okay. Good luck. Yes, ma'am.
And then we'll just get a reset on this.
Just get a reset, and your appearances, no reason for you to come, unless, of course, there's a
So, and I say that, but your appearance was waived, but then when you have the UA, because you can't go to court, then you're gonna have to
Because-
show.
Okay, yeah.
Okay, good luck.
Thank you.
Have a seat.
Should go for the SB 7. We appear upon dismissing or disposing of it.
Okay.
So they weren't able to release them yesterday because the sheriffs never created the secondary out of county.
Oh, right. So they're gonna do that now?
We're gonna do that now. I
Yeah.
just need you to write on here 1,000 or however, whatever bond you want to set, so we can do the PR bond.
Okay, I'll just put different statement.
What was the new, what was the other, was this the robbery?
Yes, this is the robbery. The robbery that never got generated as.
So 30,000 on the robbery?
Okay.
And then, okay. Ready? Yeah.
Your Honor, I'm here on an individual by the name of Suy, S-U-Y, Mahia.
Okay,
Your Honor, I haven't been able to get hold of him for the past month. He lives in San Antonio. I've called every number. His phone is
so
not.
I'll set it for bond forfeiture for Monday if you want to send a letter, you know, to the last known address, and then that way you have a CYA. You know, we can, or maybe like Tuesday, that way gives you enough time.
Tuesday with you.
Okay,
Thank you
so
so much.
SFBF Tuesday, okay? If he does not appear at that point, it gets revoked.
Yes, sir.
Okay?
Maybe excuse.
Yes, ma'am. Thanks. Hey, Blaze, sorry, disturb you. I got something else to show you too. This is a 2B. Look at the charging paragraphs.
Yes, I need to re-sign that.
Yes.
And we'll shoot them out. Sign them.
Yes, sir.
Whenever
you're ready to go.
Wait, wait, wait.
Great, there you go. Council for reset.
I don't know, do you want to amend it? Can you? I don't know.
I can definitely amend it if you said. See.
I don't know. I don't know. That's why I'm wanted to bring it to your attention. I can't just grant that. So, and then, or maybe if you want to reach out to higher ups to see what's the proper protocol. I don't know.
Council will reset.
That's what I heard. Yeah, it's still a teaching mode. I'm gonna have them look at it too.
Did we do a plea on Rivas?
What's that?
I'm not to sign, that's the same document you keep signing, it's just to reinstate the condition. It seems- I
Why
don't
would we
think-
stay in, we're still in jail?
Or in the event that you are released on bond again.
Oh. I'm ready to sign.
Yes.
Okay.
Okay, thank you.
I was actually just wondering about him.
I read your mind, Jen. I just reinstated his conditions in the event that he's released.
Yeah.
That's why.
Yeah, that's why. That. But, well, yeah, this. Could you believe that? No, it's not, no, that. A little easier.
Hi, James. Hey, morning. How are you, man?
Yeah.
Yeah, actually.
Oh, yeah. Hey, Alicia,
Yes, Judge.
did you see the BVR on Rivers? Rivers? No, I'm sorry. Montanez?
Yes, I actually reached out to that case manager right now to have her match the medications and see
Yeah,
what was tested for would be included.
I mean, before you file a BVR,
Yes, Judge.
did she do that? No. Or did they do that?
I'm having as soon as I got that email in, I messaged her, so she's looking into it now.
Okay,
And
I'll hold it.
definitely bring it up to see if it
Yeah.
is invalid, then kind of
Yeah,
nick it.
okay.
Thanks for the on the way.
No, yeah, give me 1 second. Got it. Okay, no, I'm ready. Yeah.
Yeah, this is a little different. It's a new law violation, but the client has been compliant on his probation and is driving with the license invalid. The son officer pulled him over and then they found his license and some.
But like, go for that.
No.
Motion?
Yeah.
Okay,
Who's committing a class B misdemeanor? It's just like a good reviewer.
okay.
Now he's probably in county court somewhere, right?
I'll file a motion. I don't know where he is to be honest.
What's the,
Our case number is
Yeah.
249
okay?
8880.
Yeah, he just picked up a new case with us.
Okay.
Yeah.
I'll file a motion.
He'll be here in 6 days. Hi. You ready?
Okay, Gallegos, he got out.
Come up, Mr. Gallegos. Good morning. Is it? All conditions will continue. You are not to use. Do you understand?
Yes, sir.
I will test you again in about 45 days. If you test positive again, it's not going to go well for you. I'm not asking much. Do you understand?
Yes, sir.
Okay. All right.
And
That's
we
it.
are doing, we're working on a PTI with the,
Quicker you get it done,
that's what I'm saying, with,
quicker it is for you.
they do want to test as well as a condition, so, once we test them again, then we get some.
You hold the keys to the jail cell. No one else. Do you understand?
Yes, Your Honor.
Thank you, Your Honor.
Yes, ma'am.
Thank you.
Did I get on your legs?
Judge, I have an off docket, bond conditions, first appearance, he set for tomorrow, Friday, but I'll be in.
Can I do it today? Yeah, of
Yes,
course.
I asked my client.
Oh, yeah, I'm happy to do it.
I'm gonna see, because you may want to talk to him, I'm gonna see if.
Do you need is a bond already set or no?
The bond is set and.
What is it, DBI?
Yeah.
Okay, yeah, I need him or her. So just let her know and then when you're done, bring them.
Okay, thank you.
Yes, ma'am.
I don't. I just think that's in just the bottom. Oh, okay. Karen. Thank you. Yes. Did you want 45 days?
No, 45, right?
Yeah.
44 or 5 does.
I know. Yeah, no, probably, no. That's professional. I mean. He signed up and said, he's. Well, he's trying to think. He was seen again. By the keeping it that, that's on.
I've heard back from the prosecutor. Or sorry, not case, Williams was the legal on the case.
Oh, yeah.
Said it was almost down the road, so.
Come up, Mr. Runyon.
Yes, Your Honor.
I'm going to find that there's no probable cause to go forward in your case. Aren't our streets dirty enough?
Yes.
Don't say anything, just please,
Understand.
keep it nice.
Yes, sir.
All right, please.
Lee.
Your Honor, just on news, that was because he didn't see the assault.
Yeah, no one,
Are we getting the dismissal?
That's gonna go through environmental. I've emailed her, so that's kind of.
Okay.
Hey, hi. Good morning.
You know, here for Mr. Flores, Adrian Flores. He's in the holdover. He's got a terroristic threat on a serious bodily injury charge. Represent me.
Hi, how are you?
Harold, what would you like? What are we doing?
Just today was the day we're going to come back for the mental health evaluation, and they just sent it to me this morning. Haven't had a chance to read all of it. They did say he was competent, but I still don't think something's right with him. I talked to him.
So get a second opinion. If you need money for a second evaluation, I'll give you money.
And I don't know. I mean, it might be he's competent, but just something's not correct, with our thinking and reasoning when I was.
Are you able to communicate with them?
I am. Well, just for instance,
Limited fashion or something, or what?
Sorry?
In a limited fashion or?
No, he can communicate. Just for instance, I was just told, well, I just want to go ahead and work it out because then I'm going to hire an attorney and we're going to get them all dismissed later. I'm like, no,
Yeah,
if we're gonna do this, we gotta do it now. We have to decide if we're going to trial now. And
That's
then-
I want to get out as quick as possible and then
Kind of, but that was a little more than that, though. Just,
to talk to him.
I mean, I guess it would be a safe thing. Just explain to him what's going on.
Do you mind bringing out Mr. Flores? Do you need a translator?
No, sir.
Adrian Flores, please.
And I think he understands now, but it just might be a misconception, maybe jailhouse lawyer talk or not understanding his
I don't know.
cases.
Does he have his spending in the 220? This can.
No other cases pending as far as I know.
Council, this is the only case that's not from the. Check 755 to the. There's
Yeah,
no
sure.
evidence about any charge or anything probation on felonies.
Let me just double check.
What is your cause number?
Oh, mine.
Yeah.
is 5472.
Oh, I guess that's what you have. Okay. Harold, or he's right here. Okay.
Switch.
Good morning, Mr. Flores. How are you?
Good today.
Good. The reason that you are still in custody is that we gave you a PR bond and you take off. You don't come back to court. This has not happened but once. It has happened already multiple times. So that's why I can't just continue to give you PR bonds. When you do, you just take off. The only thing I need you to understand is that, you know, when you plead guilty to something, it sticks with you forever. You cannot try to plead guilty to something, get out and try to change it or do this or do that. This is a, you know, when you do this, when you accept a plea bargain, it stays.
Judge, Your Honor, I'm truly sorry for what I've done, like my whole life. I just asked for another PR bond. I'll make it to court. I actually call my mom, see if I could stay with her until she drops me off at court, and whatever they say from there, if I'm guilty or not guilty, I'll plead guilty. Or if I'm innocent, I'll
Where are you
plead
living
innocent. My mom stays in Tomball now.
No. Are you living on the street? Where are you living?
I'm homeless, but I've actually talked to my mom, and me and her actually going into a good relationship now.
Did you just get picked up?
Like mother and son. And yeah. Like they caught me at the airport, and
Look, I don't want you to talk about the case. The thing is that I don't want to continue to give you someone a PR bond if you're just going to go to the streets. The streets are not a safe place.
I won't go back to the street. The streets aren't for me anymore, man. Like I don't want to be in the street. I don't want to be homeless anymore. And I've talked to my mom. She's doing real good, and she actually wants me to be around, pay the bills, and and own a house of my own.
Let's do this. Why don't we do a TRAS to see how we go forward? Because I don't know, and we can have the clinicians evaluate him to see how we go forward.
First.
If you want to do an independent one, I'm happy to give you money for you to do it. Or like I would suggest is just do a TRAS to see where do we go? Because I don't know, but having clinicians talk to him might be the best way to go to see how we go forward. Because the problem is, Harold, is if we just throw him out to the streets, we're throwing him out to the wolves. If he doesn't have a place to go to, or just, Whereas if we have him TRAS, we can try to get down to what the true issue is and why it keeps happening, and then we'll figure out a plan, So you just let me know whatever you want to do. I'm happy to do it.
So just we do the TRAS, we just set that up with the CLO or?
Yeah, so we'll have Shatori set it up and we'll do it. We can expedite it so it gets done within the next couple of days, so he's not just lingering.
Judge, as his competency is also good then?
Yeah, competent. Yeah,
Bur?
so we can get it done. And then that'll really tell us, perhaps he needs to be in mental health court. I don't know. But that's what we can get the TRAS for.
So what do you think, there's 2 weeks or?
No, not even a week. A week. Okay. Thanks. All right, Mr. Flores. Okay, are you ready?
Thank you, Judge.
Yes, ma'am. Alipio, come on up.
Is this the off docket, Judge?
Yes. Do you need the cause number?
Yes, 1 second.
Because it's going to be with you.
Okay,
It's 2555472.
thank you.
Good morning, Mr. Alipio.
Señor Olivia.
Yes.
Sir, you were charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 13th, 2025, an officer observed a blue Ford F-250 driving at a high rate of speed. The officer paced the Ford driving 79 miles per hour in a 60-mile-per-hour zone. The officer observed the vehicle to fail to maintain a single lane, driving over a solid dash line, and driving between two lanes with other motor vehicles in the area when the vehicle failed to maintain the single lane. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed the defendant to have slurred speech. The defendant stated he drank one alcoholic drink prior to the traffic stop. The officer observed the defendant to be staggering while walking, using the motor vehicle for support, and the defendant to have the mild odor of alcohol upon his breath. The defendant appeared confused, and the officer had to repeat himself multiple times. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 8 clues observed on the walk and turn. 3 out of 4 clues observed on the one-leg stand. The defendant stated he drank 2 to 3 alcoholic drinks prior to the traffic stop. The defendant was arrested. An inventory search was conducted of the defendant's vehicle, and the officer observed a warm to the touch white cup in the center console.
Alcohol while driving?
3 to 3/4 full while with the smell of an alcoholic beverage. The defendant was read the DIC and refused the breath test. A blood search warrant was signed and executed.
Mr. Alipio, I would hope that you would recognize it's elementary that you're not to have alcohol in the car while you are driving. I'm going to find that there is sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. I am now also taking away your privilege to drive. You are not allowed to drive. If I find that you do, because I will have you sign an affidavit, a promise with me that you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, likewise, you will go to jail. I do not know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes.
I am sending notice to DPS that there is now a restriction on you that you are not to drive any vehicle that doesn't have an ignition interlock on it. If you were caught driving a vehicle and it does not have an ignition interlock, every officer in the state will know to arrest you and put you in jail. Do you understand?
Yes.
Your Honor, just to clarify, so he can drive so long as he has a guardian?
No, I'm taking away, he's not allowed to drive at all.
Would you consider reinstating his ability to drive because owns his own business?
I'm not ready yet. All I know is that he's got alcohol allegedly in the car while he's driving, and it's a second offense. Look at me, Mr. Alipio.
Examíname, señor.
Do not drive. Do you understand?
Yes. Yes, sir.
Because of this restriction, you will now be required to obtain a portable device that you're going to take with you everywhere you go to prove to me that you are not consuming alcohol. I don't know if you have a problem with drugs or alcohol. If you do, now is the time for you to address it. Because if I see it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it.
No, te va a gustar como lo.
Do you understand?
¿Lo entiendes?
Yes.
Yes.